Good afternoon and welcome to the Appellate Division First Department. Most of you know the routine. I will call the calendar and you will each give me your requested argument time. Please know that there are already 6 hours of argument time requested this evening. So please ask for the time that you actually need, not the time that you want, understanding that the court is fully familiar with the briefs, with the record, oftentimes more than you wish that we were. And please know that the time clock is for you, not for the court. So if you are so brilliant that my colleagues need to ask more questions, I won't interfere with their request to ask questions, okay? All right, People versus Jashim Nieves. Submit. LICC versus LICC. Okay. I'm going to give you 4. Okay. Seeing as you're here by yourself. Britto versus Bethlehem Howlage. 4 and 1 and 4. Countrywide Insurance versus Zurich American. Okay. 5 and 1 and 5. Okay. Azen versus Bunning. Okay.
3 minutes for respondent.
All right. 5 and 1 and 3. People versus Sean Brown. Submitted. Perez versus 1334 York LLC.
Appellate, 4-2, please.
4 and 2 and 4. Avraham versus 235 West 108th Street.
Good afternoon, Your Honor. For respondents, 7 minutes and 4 minutes. There are two people.
Okay. Tell me who's arguing?
Nicholas Caducci, Boyd Richards for defense. I'll be taking 7 minutes.
That's what you're asking for. Okay, yeah, let's keep it straight. Okay, who's the appellant? That's who I should have heard from first.
5 and 2, please.
Okay, 5 and 2. Okay, and I had one appellant. I had one respondent. Okay. All right, so, all right, 5 and 2, 4 and 3. Okay? Lou versus Sagewood.
For appellate, 5 and 2, Your Honor.
Okay.
For respondent, 5 minutes, Your Honor.
5 and 2 and 5. S. Children. Submitted. LICC versus LICC Realty.
Appellate, 5 and 1.
Okay.
Respondent, 3 minutes, please, Your Honor.
5 and 1 and 3. 612 West 144th Realty versus DHCR. Submitted. Capital One versus Majestic Holdings. Submitted. Fall versus Greyhound Lines.
I guess I'll take 5 then. Thank you for responding.
All right, 4 and 1 and 5. People versus Amar Garcia. Okay.
People 4.
5 and 1 and 4. Holy versus Amgen Inc. is a submit. Hamway versus Sutton is a submit. First case on the calendar is LICC. Right, the first one is. Want to make sure I didn't miss something.
In that case, where that guy said there was only one respondent's brief on.
Okay.
I think the two guys can argue that one brief.
All right. On Avraham versus 235 West 108th Street, I only have one, which is why there was confusion. I only have one respondent's brief. So you gentlemen decide who's arguing. You don't get to both argue. I have one brief. Those are the rules of the court. You can step outside and discuss it. But you don't get to argue when you didn't file a brief. So decide, okay? All right, first case on the calendar, LICC.
May it please the court, good afternoon. For the respondent, prior cashman by Ronnie Schindel and Karen Platt. I had asked for argument on this matter because, even though the appellant did not, because I felt that the court might want to hear about the allegations concerning custody that were made in the motion. There's primarily three issues. There are the custody issues, there's an issue of fees, and there's an issue about some costs that were awarded to my client. But with respect to the custody issue, primarily what appellant is seeking is a hearing, which was denied below by Judge Katz. And though she presents it as a question of law, I believe it's much more than that. At the time that the motion was filed, the custody trial had not yet been decided. Custody trial took place before Judge Katz, had 9 days of testimony, had a complete forensic report done by Dr. Sarah Weiss, one of the most respected forensic custody experts in the state of New York. Also, I'll note that Judge Katz had been sitting on the case since 2019. When the trial took place in 2023, he had been involved with the case for 4 years. At the time this motion was decided or submitted in December 2023, there were 14 motion sequences. He sat on all of them. So even though the judge was clear in the decision that he felt that the lack of an affidavit of a first-hand witness who was alleging certain facts was a primary basis for not granting the hearing, if you, in the transcript, the judge is clear that he had a decision that he could have issued, but held it open because he wanted to hear what was essentially a request to modify what had been put into the trial record. So I think when you view the decision and the judge's determination that a trial wasn't necessary, you have to not only look at the fact that there was no affidavit submitted. In fact, all that was submitted in front of, with respect to the primary and actually sole allegation was a purported text from a nanny, which we believe, based as we describe in detail in the brief, didn't even allege what appellant is alleging happened. It had to do with a claim that my client's father was showering, quote unquote, with the child. We made clear that we have an affidavit of our client's father to support this, that meant that he was assisting with the then 8-year-old child, taking a shower, as most concerned parents or grandparents would do. And in fact, when we alleged this in our responsive papers, after the motion was filed, it was not refuted by Ms. LICC in her reply papers, nor did she at that time file an affidavit to cure the defect that was raised to her. I note that in my client's affidavit on that motion, he indicates that the nanny in question, Ms. Martinez, had told him that Ms. LICC tried to seek an affidavit from her, and she didn't want to do it. So therefore, I think it's pretty clear, not only based upon the complete body of evidence that the judge had at his disposal, as well as the fact that there was no affidavit filed in attempt to cure. There was a conversation between the nanny and my client, which was not refuted, and what we believe to be a very clear misinterpretation of the text that is contained in the record, that Judge Katz was completely in the right to deny a hearing, because essentially, what would the hearing be about?
Thank you.
Thank you.
Britto versus Bethlehem Holage. You may proceed.
Good afternoon, Your Honor. Pardon my, I may have overshot my request in terms of time, and I apologize ahead of time. Before I begin with respect to the issue at hand, there is a matter that has to be addressed, which is there was an item included in respondent's brief that's outside the record, which we have subsequently agreed, respondent subsequently agreed to remove from the record, and we filed a stipulation such that that item should be ignored as
Okay.
it's prejudicial. It's in footnote number 2 in the respondent's brief.
We received that memorandum.
Thank you, Your Honor. It's Appellate's position in this matter that the lower court improperly granted summary judgment with respect to the issue of threshold in this matter. In doing so, the appellate court, the lower court ignored the fact that there was the range of motion findings by the physicians submitted by the respondent in their motion were varied in substantially such that it created an issue of fact that should go before the fact finder. One of the things that the lower court did in citing the case of Perez is they said that it doesn't matter that there are varying range of motion findings. Those things are insubstantial with respect to the motion before it. It's our position that when you have two different physicians that are looking at the same range of motion of a particular body part, you can't have one physician say that, for example, 108.
Yes, but we have case law that has been developed over the years that establishes a certain bottom line that has to be established. Has your physician's submissions met that bottom line?
Yes, Your Honor. And
How?
This is not, with respect to the findings of the lower court, it's not with respect to whether or not it's 18% as the case law has found. This is an issue where the movement's physicians have given two different findings.
So did both of the movement's physicians or the examiners find that the plaintiff was in normal range of motion?
I'm sorry.
After examination, did both of the plaintiff's defendant's physician find that the plaintiff was able to move within normal range of motion? Was that their bottom line?
Their bottom
finding?
line was that it's normal range of motion.
Right.
However,
So, okay, so they both agree it's a normal range, and they're using two different sets of AMA guidelines, right?
Well, that's
There are
brought before the
difference.
court
There are
out-
difference.
again, that's brought before the court without substantiation by a physician who says, my guidelines number 5 and my guidelines number 6 all render different positions.
But they both come to the conclusion that you don't dispute that the plaintiff was able to move within normal range of motion.
They both come to a conclusion that one says, for example, 90%.
I'm asking you, their bottom line conclusion is that the plaintiff was able to move within normal range of motion, correct?
Correct, Your Honor.
Okay.
What do you understand that the normal number vary by a 30% difference?
Was that finding refuted by objective findings in the reports of Dr. Kotkes and Kramer?
Yes. So,
There was a numerical finding as to range of motion, loss of range of motion?
right. So in terms of the surgeons here, Your Honor, the underlying court says the plaintiff's physicians only looked at things such as the pain complained of by
So
the doctors.
in what page of the report are the objective findings?
So if you look at the record at 305,
As to range of motion?
the range of motion, it's within the 320 to 329. The issue is that,
Well, you'll have time on rebuttal. I think you've answered my colleague's question, and you'll have time to assert other arguments. You may proceed.
Good afternoon, Your Honors. May it please the court, Ryan Dempsey with the law firm of Gordon, Reese, Scully, and Manzucani for the respondents. Judge Moyne's decision, 12-page decision below, was correct. Summary judgment was warranted and proper in this case. Defendants' physicians, Drs. Bender and Bezos, as Your Honors have pointed out, found full and unrestricted range of motion. I believe that the differing numerical values for what's considered standard is a red herring. The standards of Dr. Bezos record at
I don't think it's a red herring. There were different additions used, which accounts for the different scale that was utilized.
And as you rightly pointed out, there's an established body of case law in the First Department, the Feliz case, which is a 2011 First Department case, as well as the Anderson versus Zapata case.
So defendants' doctors found that the shoulder injury was degenerative, correct?
Correct.
And did the plaintiffs' experts refute that or address it in their opposition to the motion?
Well, I would respectfully submit they did not, Your Honor. The plaintiffs submitted the affirmations of Dr. Cotes and Dr. Kramer.
Did either of them discuss the findings of degenerative?
They don't address in response to Dr. Bezos's opinion that it was degenerative in nature. They also do not address plaintiffs' prior and subsequent accidents.
Right, so when they did, I think one doctor did his report at least, it was after the plaintiff's, what he called major accident, correct?
Correct.
And did that doctor address whether or not the major accident had any impact on the plaintiff's claims of serious injury?
Not mentioned in either report from plaintiffs' treating physicians. I would argue and submit that under the Franchini versus Palmieri Court of Appeals case, that the opinions of both doctors, Cotes and Kramer, are therefore speculative and meaningless as a result.
Were there
Moreover,
objective findings offered?
were objective findings offered.
Numerical findings as to range of motion?
So Dr. Kramer and Dr. Cotes did give range of motion findings. However, and this is something that Judge Moyne points out in his decision, they failed to correlate those findings with any restrictions in the plaintiff's activities, which under the Stevens versus Homiak transport case is insufficient to establish.
The only restriction was the inability to go bowling, right?
Plaintiff testified that his only limitation in the 90-180 category was he couldn't go bowling, yet he couldn't explain adequately under oath how you score bowling and couldn't mention the last time that he had gone bowling. Everything else in terms of the plaintiff's daily activities, he was able to dress, bathe, clean himself, care for his mother, took a vacation to Puerto Rico, and as you rightly pointed out, the only thing he says he purportedly couldn't do was go bowling.
Thank you.
Thank you very much.
So, with respect to permanency, one of the things that the lower court dismissed that this plaintiff had a portion of his body removed during surgery. So it's a discectomy where there's a permanent removal of the disc from his body, and which satisfies the
But the issue is whether the reason for the removal of that disc was the accident. That's at the end of the day, the issue, right?
And that's the intraoperative finding by the physician, which he correlates to the accident, and that in itself raises a dispute between multiple experts, and such it should be submitted to a jury to determine which expert, if any, is correct. When there are disputes between two experts, similarly with respect.
No, but I mean, our jurisprudence says once the moving party makes its prima facie by putting up two doctors who say that this is not a permanent injury, the answering or opposing has to deal with the reasons why they say it's not. And your doctors, neither one of your doctors dealt with, one, the finding that, for example, in the shoulder it was degenerative and that a lot of it was degenerative. Neither of your doctors even addressed that. And neither of your doctors addressed his prior accident or his subsequent accident.
Right, I would disagree. In fact, that there's nothing in the prior accident that relates to the shoulder. There's nothing in the second accident.
Is there anything that did your doctor say that?
Well, why would you need to address an injury with respect to the shoulder when there's no complaints of the shoulder?
Doctors attributed his injury to degenerative causes.
Right, they don't attribute it to a prior accident.
Counsel, it really helps if you allow the court to finish their statement before you jump in,
So
okay?
to raise an issue of fact, your doctors have to dispute that.
Well, and Your Honor, that's what I'm saying. They intraoperatively determined that the injury was causally related to the accident, and therefore, it's not degenerative. Both doctors say that.
Thank you. Countrywide versus Zurich. You may proceed.
Thank you, Your Honor. Good afternoon, Your Honors. Jason Levine for the plaintiff appellant. First, we submit that there were factual questions as to whether Zurich's affirmative conduct in the defense of its insured acted as either a waiver or an estoppel to its seeking reimbursement of its attorney's fees and defense costs incurred in the defense of the underlying wrongful death actions.
So, counsel, how do you correlate your argument with the rule that automobile insurers are not excused from their defense obligations to defend by exhausting their policy limits?
Right, well, that's part of the argument here, Your Honor, is that yes, Countrywide tendered their policy in January 2017, and they continue to defend their insured, the tractor owner and the driver. I just want to weave this in because we start with really that letter of January 8th of 2016 from Zurich's third-party administrator, which expressly stated that Mr. Boltz, Zurich's insured, would be providing their own defense in the underlying action.
There was an ostensible conflict of interest, right, between Glenson, the owner of the tractor, and Mr. Blutz, the owner of the trailer. So using Zurich make kind of sense, right?
Well, it's not, I would dispute that there was a conflict.
There could have been a conflict.
Well, there could have been, but
So does he wait until one exists before you get a new attorney?
well, no.
There's nothing wrong with them having gotten counsel in light of their perception that there was a potential conflict between the parties.
Well, it was their position, Your Honor, that Countrywide should have taken on the defense of their insured. That was their position, ultimately, and that's why they're seeking counsel fees. But they went ahead voluntarily retained their own attorneys.
Did you disclaim coverage? Did you
I did not
disclaim, did you reject their tender of defense?
I'm sorry, Your Honor, I couldn't.
Did you reject their request that you take over their defense?
What they did was, right, in February of 2016.
She's asking you what you did,
No.
and your response is what they did. So pay attention to the question. The question was about what your client did. So how about you answer that question?
Yeah, I was about to, Your Honor, I'm sorry.
Good. Start with that.
February 2016, Countrywide responded to that. And yes, they did reject the defense.
So at the time that they're having their own attorney, you've rejected the notion that you should cover their defense, right?
At that time, yes.
And that's where they're seeking the attorney's fees for, that period, right? Particularly that period. Because it was right after they said, we're hiring our attorneys, that you said, well, we're not taking over your defense.
Well, I should point out the timeline here is that after that January 8th, 2016 letter, before Countrywide even responded, Zurich retained their own attorneys and interposed an answer in the first wrongful death case. And we submit that because the motion court found that, she acknowledged,
Well, if you thought they waived, then why did you say we're not going to cover your defense? I mean, your own actions, right, seem to disprove your view now that they waived it. If the only way they would have waived it.
Again, we would submit that following that initial letter and all the actions that Zurich undertook, including retaining their own attorneys, essentially taking on a very large role in the defense of those two cases.
You would agree?
Put the
Well,
lead on it.
Counsel, would you not agree that we know that the primary generally goes first and then the excess, correct?
Yes.
And my understanding is that somewhere in this record, on the plaintiff's side, a demand was being made of $8 million. And the primary is $1 million, the excess is $3 million. So the excess had a real concern under these circumstances, so they want to be able to have some kind of role to play. And so it makes sense to do what they did in this context without waiving their rights to be able to have counsel defend them. Wouldn't you agree?
Yes, certainly an excess has a right to participate in defense when, as here, from the outset, it was clear that their policy was going to be triggered, as you point out, Judge. I think the initial demand was $8 million. There was a punitive damage claim as well. Again, this ties into a separate argument in our brief. I think it's point 2, that since this case settled in excess of Countrywide's policy, of their primary policy of $1 million, that Zurich is not entitled to their defense costs. We cite a case.
You can't do that, counsel. Isn't it the primary insurer's responsibility to provide a defense? The defense,
I'm sorry, right, in terms of in the first instance?
irrespective of whether the policy is exhausted. That's the question that I asked you at the outset. But you can answer it later.
No, and they did. The Countrywide took on the defense of the owner and operator of the tractor. They voluntarily took on the defense of Mr. Boltz, who, yes, was insured under the policy by virtue of the the trailer being
And
attached.
so your argument, I want to make sure I understand. Your argument is that by virtue of their opting to safeguard their own interests and putting counsel to defend them, they waived all other rights that they had coming to them from your client. Is that your argument?
We would submit that under the facts of this case and the manner and the evidence in this record, that they waived their entitlement to seek reimbursement from Countrywide for the attorney's fees.
So the answer is yes. You'll have time on rebuttal.
Thank you, Your Honor.
May it please the court, Don Sampson for Zurich. And I'm here pro hoc vice, Your Honor, and I have a New York counsel for me to ask permission for me to argue.
She didn't ask.
Your application is granted. You may proceed, sir.
Thank you, Your Honor. And in answer to Your Honor's questions, yes, New York law is very clear, and we've cited cases on page 10 of our brief to the effect that where you have a
You're talking too fast and too low.
Bring that mic closer to your mouth so that we can hear you, okay?
I'm sorry, I
All
will
right.
try to speak a little louder.
That's good.
New York law is very clear that when you have a excess and primary insurers providing coverage for the same insured, the primary insurer has to provide the defense up until the time that its policy is exhausted. And in this case, Countrywide attempted to avoid its defense obligation by tendering its policy limits and the defense obligation to Zurich. Zurich never accepted those obligations, and counsel never says that we did. But let's assume that the tender was made. As I mentioned, we never accepted it. Countrywide never exhausted its policy at that time. In any event, a tender is not an exhaustion of the policy. Countrywide did not exhaust its policy until 2022 when it paid out the remaining limits on its policy.
How do you respond to the waiver argument?
There was no waiver, Your Honor. As early as January, or when was it? In early 2017, we made it very clear that we were seeking to recover defense costs from Countrywide.
And when did the case settle?
2022.
So 5 years after you said, we have our own lawyer because you've disclaimed that you've rejected our tender, and 5 years later, the case settled.
5 years later, the case settled, Your Honor. And our counterclaim and affirmative defenses seeking defense costs remain pending throughout the 5 years. I don't know how that constitutes a waiver, and I suggest that it does not constitute a waiver. There are other reasons why Countrywide could not disclaim itself of its defense obligation. One is its own policy language. We quote the policy language in our brief, Your Honor. What their policy language says is that effectively says that our duty to defend continues until we have paid our policy limits. Not tender our policy limits, but paid our policy limits. Countrywide doesn't respond to that. It ignores its own policy language. I suggest that they've actually conceded that point because they don't respond to it. Another reason they couldn't disclaim their defense obligation was the New York regulation, which was relied upon by the trial court. And that regulation says, as construed by the courts that an automobile insurer, excuse me, has the obligation to continue to defend its insured until the end of the case. The trial court quoted language from the regulation in its decision in that case. Countrywide does not address that regulation here on appeal in its opening brief.
Talking about section 61.1B?
Yes, Your Honor, or in its reply brief. I suggest again that maybe Countrywide has conceded that argument by not addressing it. The fact that we provided a defense for our insured also does not excuse Countrywide from the obligation of paying for that defense. And Your Honors at the outset noted very clearly why. There was a conflict of interest. The conflict of interest was created by Mr. Bolt's filing its cross-claim for contractual indemnification against Glenson and the driver. And this court has indicated that under those circumstances, a conflict of interest potentially arises, which entitles the insured, in this case Mr. Bolt's, to be represented by independent counsel. Independent meaning having no affiliation with Countrywide. And that's what this court held in the East 51st Street crane collapse case. That case has very similar facts here. The insured property owner in that case was sued along with two of its contractors for property damage or for the collapse of a crane. The property owner filed a cross-claim for contractual indemnification, and this court said in that case that the property owner, who was an additional insured on his contractor's policies, that the property owner is entitled to independent counsel paid for by the contractor's insurers, and that's exactly what should happen in this case, Your Honor.
Thank you.
Thank you.
Counsel, you have 1 minute.
Your Honor. Yeah, just very briefly, I started pointing this out during my main argument, is that I'd just like to bring the court's attention to the argument in point 2 of our main brief and reply brief under the Belmer case that we've cited. And again, I won't quote it just in view of my shortness of time, but it talks about the interplay between primary and excess carriers, where they have a mutuality of obligation, as is the case here. And just briefly, the obligation of payment should be dependent upon the realities of the litigation. We submit here under the realities of the litigation that Zurich's policy was in play, and their obligation to pay either a judgment or a settlement was evident from the outset of this case. And then under the circumstances here, they took on their own defense. And then in view of that, and since the settlement was above Countrywide's policy limits, that both parties, that Countrywide and Zurich, are responsible for payment of their own attorney's fees incurred in representation of their own insureds. Unless the court has any further questions.
Thank you.
Rest on our brief. Thank you.
Azen versus Bunning. You have 5 minutes. You may proceed.
May it please the court. Good afternoon, Your Honors. Benjamin Baker of Newman Ferrara on behalf of the appellant, Wendy Hazen. The court below committed reversible error in 4 principal ways. First, it accepted the VDA report as irrefutable evidence that the $4 million elevator improvements unilaterally approved by the board constituted repairs.
Well, let's start with that, counsel. So I'm sure you're familiar with the business judgment rule that's applicable here, and I'm sure that you're familiar with Pomerantz, which said in 2015 that the modernization of elevators is maintenance and not an improvement. Here, the VDA elevator report said that although the elevators were in fair condition, the parts were obsolete, a service disruption could last days or weeks, and technical support was difficult to obtain. So, how does the business judgment rule help you here?
So that aspect of the VDA report only relates to one part of the elevator improvements, and that's the control systems that it said were rendered obsolete.
So in your view, the board, the condo board of managers could decide that, I'm sorry, let me change that. You're positing that the board of managers could have opted forego the repairs and risk having people get stuck without elevators for weeks or days or weeks?
No, Your Honor. The VDA report looked at all aspects of the elevator and found that that was the only part of the elevator that was obsolete or in a state of disrepair.
Well, but a controller is an intricate part of an elevator, is it not?
It is.
I mean, all the mechanical parts work together.
Well, no, they could have replaced just the control systems, and then they could have submit the rest of the elevator improvements to a vote, as is required under the bylaws.
And what expert report said that the repairs could be done in the way that you're suggesting? That an old elevator that is so old that you can't even find parts for it anymore, that we can swap out a control system from a newer model that may, or I don't know anything about elevators, right, in terms of the mechanics of it. So what expert report do I have in my papers that tell me that that was even an option, to just fix the control panel, and somehow that would prevent this elevator from falling into disrepair again and again and again and leaving its tenants without ability to get up and down?
The VDA report is that expert report. It says that they needed to repair the obsolete control systems, and then it said that they also it recommended long-term improvements over the next 1 to 3 years separately that were the rest of the elevator improvements. So
Counsel, I don't think you're appreciating the import of the question that was just posed to you, because, and I don't think I'm going outside of the record, but anybody familiar with elevator repairs knows that it takes a long time to get elevator parts, period. So here, we're talking about equipment that's obsolete. Is there any report that specifically says, it specifically counters what VDA says, to wit, the parts that were needed for the controller were not obsolete, and in fact, they're readily available?
respectfully, we don't even know what was in the elevator improvements at all. The VDA report is all that's in the record.
But you had the ability to counter that, did you?
No, we haven't been through discovery, so we haven't had any opportunity to see what the elevator improvements entailed.
But just looking at the controlling bylaws here, I mean, your position really is that 70% of the residential unit owners should have had a say for this $4 million expenditure. That's really the core of your appeal, correct?
Right.
But then when you look at the language and understand what's going on here, this wasn't the replacement of all the elevators, like in terms of a capital improvement. It was designed, as my colleagues pointed out, based on the VDA report, to try and prevent a major shutdown by taking care of certain component parts of it, correct? Now, it would have been nice if it was only worth $99,000, but it didn't work out that way, correct? So it's against that backdrop that we're determining whether the board had the discretion to do what it did. And given the Pomerantz case that was cited to you, it seems to me that on this record that this would fall under repair and pretty much justify what the Board of Managers did, no?
No, because the VDA report establishes that only part of it was a repair. So if there's a project that is both repairs and improvements, our position is that when that project costs more than $100,000, 70% of the residential unit owners need to approve it. So, yeah, that's our position.
All right, you'll have time on rebuttal.
Good afternoon, Your Honors. Barry Margolis for the condominium defendants.
Could the repair of this elevator be piecemealed the way counsel is suggesting?
Not at all, Your Honor. If you look at the record and you look at what the VDA report made recommendations at the record 122 to 24, VDA makes clear that their recommendations of rebuilding, replacing, upgrading specific elements of the elevator system, including hoisting machinery, sheaves, bearing, drive motors, power drives, signal controls, wire ropes, et cetera, et cetera. So it's very,
Sounds like the whole elevator system.
sounds like that, Your Honor. And the Pomerantz decision and the decision there interpreting what an improvement is and making that distinction between what a repair is really is at the heart of this argument. And the judge below obviously heard the arguments relating to construing what it meant under the bylaws. He also made the argument and obviously evaluated the business judgment rule and determined that when you couple the interpretation of the bylaws as to what is an improvement to determine the authority of the board, and then the deference that the business judgment rule gives the board to do what is absolutely necessary. That is why the judge specifically ended the decision by saying that to hold otherwise would effectively hamstring a board's ability to maintain the building and prevent it from falling into a state of repair. And what the argument of the plaintiff or the appellant here is that if the cost is of a nature that the unit owners need to vote at 70%, they get to decide what's in the best interests of the entire community versus the board who's charged with the fiduciary duty to do that. That is essential to what the board does, is make the determination how to keep everybody safe. That's what they did here. Unfortunately, it did cost a lot of money, but this is a 863-unit building. This is a huge 57-story condominium. This is not some small condo with 6 floors and maybe 50 units.
Counsel, even though the report talks about long-term improvements, probably not the word that maybe now you wished that your expert has used, you're saying that was part of the repair and maintenance obligation to keep the elevators working, to keep them up to date with what was happening in the world of elevators.
100%, and the use of improvement by VDA, they're not using it in the
They're
terms
not
of the
lawyers?
bylaws, and they're not lawyers.
They didn't look in Black's Law Dictionary to see what the word improvement
No,
meant?
I wouldn't see that many elevator contractors walk around with Black's Law Dictionary. So perhaps the use of the word was not appropriate, but I think the record is very clear here on why the board did what it needed to do, and it's protected by the business judgment rule. We'd ask that you'd adhere to the decisions below. Thank you.
And you'd be here for other reasons if you had not fixed that elevator and 863 residents of your buildings couldn't get up and down their luxury condominium.
Or worse things we might be here on. So,
Yeah.
yes. Thank you, Your Honors.
So we, at the very least, we think that the VDA report is not conclusory evidence that establishes that we don't have a claim as a matter of law. The note that it requires an improvement is a triable issue of fact that should have prevented it from.
Counsel, I'm looking at the report which states in pertinent part that signal controls and solid-state motor drive systems are no longer being manufactured by CEC Futura, which I believe went out of business, right?
Correct.
And are now considered obsolete. The microprocessor control, presently one of the weakest links is in the system, is nearing the end of its life expectancy. How would you argue that the Board of Managers was merely exercising its fiduciary obligations?
Because if you include repairs, any repair in a project that also includes many improvements, then there's no purpose left for the bylaws provision that requires 70% residential unit or approval for improvements. If any project can include something like the replacement of the control systems and then also include all these other elevator upgrades, including some that aren't even recommended by the EDA report, then there's no time when they...
You have any case law that backs you up? Because it doesn't look like...
Well, all the Pomerantz
kills you.
Pomerantz, Genis, and Helmer all say that the conditions were in a state of disrepair that were being repaired. In Pomerantz, it was because a water tower flooded the building. In Genis, it was because these wooden components of the building were decayed. And in Helmer, it was because there was a leaking roof. Here, nothing happened to the elevator that caused harm. There was nothing wrong with it. It was potentially obsolete and that part needed to be fixed, but there was nothing else that needed to be done at that point in time, so it was not in a state of
Just the
disrepair.
control system.
That's right.
That's like, I just need a new heart. Okay, I got it though.
Thank you.
Perez versus 1334 York Avenue.
Good afternoon, may it please the court. Michael Cassell for the plaintiff appellant Percy Perez. This is a labor law 240, 241-6 case. It's not disputed that my client fell off of a scaffold, a mobile scaffold that lacked guardrails. The defendants argue that there's two issues. They argue that my client moved the scaffold that didn't lock the wheels and that there were guardrails somewhere on the site. As we set forth in our papers, as far as the moving the scaffold issue, there's numerous cases from this court that all say that moving a scaffold, even if true, which my client adamantly denies, it does not make him the sole proximate cause of the accident. So I'll focus on the guardrail issue. The guardrail issue, defendants submit 4 affidavits, and I know the court likes photographs. I think the court likes photographs because I was here a few weeks ago and the court seemed to enjoy photographs when I was a defendant.
Except the only thing that these photographs show me is a scaffold in violation of 240 sub 1. Because it has no railings.
I concur. My client was there 6 hours, Your Honor. He starts work at 11:30 that day. The accident occurs at 5:40. They submit 4 affidavits. 3 foremen who said, we looked at the scaffold. This is the scaffold.
No, this was an incredible work site. All 4 foremen inspect this scaffold. And all 4 foremen allow this plaintiff to get on the scaffold with no railings. Every single one of them.
Correct. 6 hours he was
Now,
there.
wait a second. Wait. I'm gonna ask you. Those affidavits don't say, sure, we told the plaintiff to get on that scaffold that doesn't have the railing, do they? Those affidavits say he knows he's supposed to attach the 2 parts of the railing. The railings were there for him to attach, and he didn't do it. That's what those affidavits say, right?
Not exactly.
Okay,
The railings
what is missing from that?
Well, the most important part is the affidavits say, we, as a labor law defendant, are going to shift the onus onto the plaintiff to put these guardrails on. I submit number
So
1.
the same way, for example, someone would say, I have to put goggles on that are given to me, right? That doesn't shift the burden on the person to use the materials that are given to them, does it? Would
Does
you?
to the extent that the affidavits are occasionally silent to that missing link where they say, we actually said, Mr. Perez, here are the guardrails. They're somewhere on the 5th floor. There's no, that link.
So it's your position that 3 minutes before he got on, that they had to say to him, you have to do this right now? Or that, for example, what they say is that they had the guardrails. He knew he had to put the guardrails on. The guardrails were there, which he disputes. No doubt. He says, I asked for the guardrails. Clearly, he knows he needs to put them on, and there were none, right? That's what he says, right?
He does say there were none.
Yeah, he says, I asked for them, and I was told there were none, right?
Did he have to ask for them?
I don't believe he did. I mean, under.
Does a owner and a GC have a non-delegable duty under 240 sub 1 to provide safety devices for a height elevated risk?
Of course, Your Honor.
Period, full stop. Not maybe, in case, if last week I told you, none of that. You must, if you are a owner or a GC on a construction site, putting a worker on a scaffold, you must, according to the codes, provide railings. Not over there, not look around the corner, see if somewhere around the 5th floor you can find the guardrails. They must be readily available. What proof in this record is there, other than an affidavit from someone who is not deposed? Where are these? Is there a photograph anywhere in this record that shows me any guardrail on site, on the 5th floor, anywhere at any time?
No, and I submit it's even better, Your Honor, because the 3 foremen all said, we inspected this guardrail. We saw the guardrail, This is the guardrail we provided to Mr. Perez to use for 6 hours that day. There's no
Do
guardrail.
those
Wait,
affidavits
you
say-
mean the scaffold, not the guardrail?
I'm sorry, we provided.
You
this
provided the
this
scaffold, right,
without
okay,
guardrails,
right,
correct.
okay.
Do the affidavits say by these foremen, we told the plaintiff before he got up on the scaffold, there are the railings, put it on before you start their work. Is there any allegation in any of those affidavits, as is required by this court's jurisprudence, that they said that to this worker?
No, in fact, that link is missing. They're so cagely drafted. They missed that exact link. They're never provided.
Thank you.
Good afternoon, Your Honors.
I haven't, I'm sorry.
Sorry.
Finish your appearance, please.
Sure. May it please the court. My name is Mark Potak, calling
Can
in
you see
Dykeman.
we're excited about your case? Go ahead.
So I have an easy question for you, counsel.
Sure.
Where were the guardrails located? The ones that the plaintiff was supposed to install on the scaffold. He worked on the 5th floor. The affidavits state that the guardrails were on the 5th floor. Where on the 5th floor?
I believe the affidavits state that they were in the immediate vicinity.
No. That's not. Immediate vicinity is everywhere and anywhere. Where?
Well, the plaintiff testified that the 5th floor at the time of the accident was
No.
a wide open
Where
space.
did your affidavit of affiance say? Because I looked, and every single one of your affidavits say almost exactly the same thing. So whatever attorney drafted it was pretty good. He was consistent, except for a couple of sentences here and there. But nowhere in any of those affidavits does it say they were right on the left-hand side of the room he was in.
That's right.
Nowhere. There's not a photograph. You attach the same picture to 4 affidavits. And as I said in my first question, the picture is damning because the picture shows me a scaffold in violation of 240 sub 1. So please show me where in the record I have proof other than some statement in an affidavit that is not confirmed by anything. Where? Show me where in the record I have proof that there were actually railings on site on the 5th floor that this plaintiff ignored.
Other than the 4 affidavits which corroborate each other, that's all I have.
Right,
Your Honor.
because that's just words.
So wait
I
a
have no
second.
photograph.
In your,
The only- if I
right,
can-
are affidavits evidence that one can put in that would raise an issue of fact? These are people who have personal knowledge, right?
Correct.
And from their personal knowledge, they testified under oath that there were guardrails that the plaintiff were right there for the plaintiff to put on. What I want to ask you is why aren't they put on first thing in the morning?
Well, Your Honor, Christopher Samis, who is the foreman who's in charge of, he's the top foreman, I forget his exact position, but he said that he's the one who actually set up the scaffold and set it up with the guardrails that morning.
Yet I don't have not one picture of a scaffold with a railing. Not one.
My clients didn't take photos every time they set up a scaffold, and there's no onus for
So
them to
a
do
guy
The photograph, which was
falls and is sent to the emergency room, and your people decide, let's take a picture of the scaffold in violation of the 240 sub 1, and not take a picture of the railings that are right there that this worker ignored and did not use because we're going with he's recalcitrant. He's the sole proximate cause. So how about you give the court a little proof?
Well, Your Honor, I would submit that these gentlemen who took the photographs were construction workers, the same kind of as the elevator workers who don't carry Black's Law Dictionary. They're not familiar with-
Counsel, please.
They're not
If I'm in
familiar
a car accident, it's called a cell phone. You take a picture of the accident. This ain't rocket science.
Your Honor, we're not.
You're telling me that somebody at a work site, really, that's your argument?
We're not disputing that the scaffold lacked guardrails at the time of the accident. That's never been a dispute of ours. What we're disputing is that they were available in the immediate area. Plaintiff was trained to use them. Plaintiff knew they were available or had reason to know they were available.
here's the
And plaintiff's
problem.
Testimony about whether he asked for them is entirely equivocal.
All right, counsel, a little different question.
Sure.
What we see in many of these cases is usually that a worker is usually told, put the safety equipment on, you know, in terms of to protect them from fall injuries, you know, hard hat, things of that nature, certain kinds of belts, et cetera. What's unique here is that this particular plaintiff was, before he even started working, was subject to safety classes, specifically on guardrail. That's in the record.
Yes, Your Honor.
He was trained to know that before I use a Baker's scaffold,
Yes, Your Honor.
I have to take those rails and put them in.
Several safety classes through OSHA and through his own employer.
Right, and
general
on this
contractor.
record, each of the four people say this is an ongoing duty, well, not duty, but an ongoing responsibility on the part of the worker here, correct?
Right.
And so this, Mr. Perez knew this.
Can you tell me what case in our jurisprudence says that safety meetings at some time prior to an accident constitutes a safety device for an accident? Tell me what case stands for that proposition.
Your Honor, that's not a proposition that I've taken.
Okay, so it doesn't. That there is no case that says that, because our case law says that prior safety meetings and instructions on what to do is not a safety device. That in order to say that a worker is the sole proximate cause, one must find that prior to the accident, immediately prior to the accident, he was instructed to do X, refused to do X, refused to use the safety device that was offered, and fell or got hurt.
If I could respond, Your
Isn't
Honor.
that what is required?
I believe that it's slightly more nuanced in that the Court of Appeals in the Cahill case, which I cited, says that, quote, where an employer has made available adequate safety devices and an employee has been instructed to use them, the employee may not recover under 241 solely by violation of those instructions.
How do we define available?
Available, I would suggest, would be in the immediate vicinity, like is in the case here.
Okay, how do we
cite your
define
colleagues'
immediate vicinity?
I would say within sight, within 30 to 50 feet, that's something that would be...
And what proof is there in this record that there were railings within 30 to 50 feet of where this plaintiff was working or within his visual sight? What evidence is there of that?
the four affidavits which corroborate each
The
other, taking with the
affidavit
plaintiff's
said
testimony,
that
which...
it was on the 5th floor. It didn't tell me where. And if I am wrong, if I read it wrong, tell me where I read it wrong, what number, because I read all of them and marked them up.
I don't have it
And
handy.
none of them tell me exactly where on the 5th floor these supposed railings existed.
If I could address one of the other points that you're...
No, I want you to answer my question.
I don't have that handy, Your Honor.
The
Okay,
problem,
then your time
I
is
want to,
up.
can I ask one more?
Yes, you may, of
Yes,
course.
may I just want to ask you, is it your position that the foreman literally immediately before the worker uses the device has to say right, like within 5 minutes before, put those railings up? Have you seen
No, Your Honor,
any
thank you, and that is
cases?
not our position. Our position is the opposite, that
Right.
it shouldn't have to do that. This is like you can lead a horse to water kind of example, Your Honor. It would be ridiculous to require...
But we both agree that it can't be like 6 months ago, we just did a safety message, memo that
Right, but as
says-
your colleague brought up, when someone's been trained over and over and over again, this gentleman's 60 years old.
Do I
all
have
his
dates,
life-
you saying he was trained, do I have dates in those affidavits of when that training occurred in relation to this accident?
I have dates that were provided by plaintiff in his own testimony.
Do I have dates in the record?
We have the dates in the record based on his safety orientation form, which was based on his safety orientation with structure tone at the project when the project began, which did include fall protection and use of safety rails, et cetera.
And
That would be the most recent
How long
date.
ago, how long before the accident was that training?
I don't know offhand, but it's in the record, Your Honor.
Okay, I
so
will look
counsel,
for it.
if I may.
Thank you.
So counsel,
I'm sorry, there are, Your Honor.
He
sorry
has,
to interrupt.
she has a question.
There are also toolbox talks.
She
with
has a
text.
question.
Sorry, Your Honor. Go ahead.
okay. So we're aware of an email that was sent in November 2018 with respect to the delivery of scaffolds and guardrails to the premises, right? Is there any indication in the record where that delivery was made?
No, Your Honor, we're not really hanging our hat on that point. That's something that serves to bolster and corroborate the other evidence we have. Again, we were brought into this post-accident. Had we had the opportunity to gain other documentation or encourage them to make such documentation, they would have.
So to the extent that the plaintiff says there were no guardrails, period, do you really meet your shifting burden of proof by having those affidavits saying, yeah, they were on the 5th floor? Is that sufficient?
I would, and I would say even solely based on Mr. Samise's affidavit, as he was the one who constructed and inspected the scaffold on behalf of Commodore that morning, and he did it so with the safety rails intact. So that would show that they were at least there that morning. If they were removed later by plaintiff, I can't say. He denied they were.
So somebody took them off?
As
of all the scaffolds? Okay.
Well, not on all the scaffolds. On the subject scaffold, we're here to discuss, Your Honor.
Okay.
Thank you.
All right. You have a minute on rebuttal.
I'll respond just to two issues. First, with regard to the Samise affidavit, I don't see anywhere in there where he says, I constructed the scaffold and there were guardrails on it. Secondly, the Cahill case, which Your Honor pointed out, I think is really a great case for plaintiffs, because in Cahill, the plaintiff's on the Triborough Bridge. And on the Triborough Bridge, there's numerous places in which to connect harnesses. And the plaintiff has a harness on. In other words, he's provided with, i.e., the guardrails. So he has on a harness, and he says, don't worry about it. I'm going to take off my harness and now walk on somewhere on the Triborough Bridge where there's places to hook the harness, and he falls. In this situation, my client, if he took guardrails off and then said, I don't need the guardrails, I'm taking them off, and falls off, you have a Cahill situation. There's no guardrails. They were never on it. We have the pictures. The order should be reversed.
Sir, in Gallagher, the Court of Appeals said that liability under 240 does not attach when the safety devices that plaintiff alleges were absent were readily available at the work site, albeit not in the immediate vicinity of the accident. And plaintiff knew he was expected to use them, but for no good reason chose not to do so. In light of that statement from Gallagher and the content of the affidavits from your friend, which at least in opposition to your motion for summary judgment we have to take as true, how is there not a triable issue of fact as to sole proximate cause?
Sure, a few reasons. First, there's no evidence exactly where these were on the sites. They say somewhere on the 5th floor. But secondly, this court's addressed a virtually identical issue in the Linares case and also the Lamache case. The Lamache case said that the device must be provided and the worker must ignore an immediate instruction to use the device. There's no immediate instruction. There's some general claim that the client was supposed to know. And also, like I said in Linares, they pretty much said the same thing, that somewhere my client was supposed to know to get the ladder, he's supposed to get the ladder and basically use it. And this court aptly noted that when the worker's working there all day, like Mr. Perez for 6 hours, you can't say the worker is the sole proximate cause for the accident when there's no guardrails provided. Any other questions? Thank you for your time. Thank you.
Abraham versus 235 West 108th Street. You may proceed.
May it please the court, my name is Justin Gannell. I am from the law firm of Sher Tremonti, and I represent the plaintiffs' appellants in this matter. The trial court erred below in granting summary judgment in favor of the defendant co-op and in denying summary judgment to the plaintiffs. The trial court erred in the wholesale application of the business judgment rule and in awarding legal fees. I'd like to start with the legal fees point. The grant of legal fees in this case comes from the proprietary lease, clause 26, and that clause expressly requires that there be a default of the tenant in order for there to be an award.
Not necessarily. It also says that there's a certain kind of counterclaim. Like in this instance, you were seeking to hold the defendant to allowing him to have the Whirlpool tub. I mean, that's your claim here, that there was waiver, that they had no right to prevent him from getting what he initially had when he first bought the apartment years ago. It's not that clause doesn't limit it to just a default.
That's a fair assessment of the claims. However, I think clause 26, in no uncertain terms, only provides for legal fees at any time hereunder, whether lessee is in default, and then there's some other language after that, but there's at least 4 or 5 First Department cases that construe this precise language and make very clear that in a situation where there is an attendant default, legal fees can't be awarded under this type of language. We cite those in our brief in their first department cases. We also think that the co-op never asked for that default finding down below. The trial court never made a finding of a default. In order for there to have been a default, the lease also requires that there be notice and an opportunity to cure, and that notice has to be done by a certified mailing. None of that is in the record. None of that was done. And in fact, there is no evidence even now of any default by my clients. My clients were told, don't put the tub back in. When that directive was issued, they did not put the tub back in. It's still not in to this day. They complied with the rules, so there's no argument that there is a default. So we think that the legal fee determination is erroneous. We also believe that the lower court erred on the breach of contract claim. There is very clear case law that for a breach of contract claim, the business judgment rule does not apply as a defense. And here our grant.
So counsel, help me here.
Correct.
So 19B of the proprietary lease says that if the lessee shall have removed from the apartment any articles or materials, how does it keep going? Or any fixtures or equipment necessary for the use of the apartment, the lessee shall either restore the articles, materials, fixtures, and so on, and repair, blah, 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 or replace them with others, and here we go, of a kind and quality customary in the building and satisfactory to the lessor. So doesn't 19B say that the lessee doesn't have the final say as to what equipment shall be restored?
Sorry, 19B is what?
Yes, please.
So yeah, right, 19B deals with the removal of fixtures.
It's the very last sentence.
Correct. And here, my client did not do the alteration. He's not terminated the lease. He's not left the apartment. It's not, and this is not an alteration. It's also just a repair. And it's interesting, under the logic of the lease, what happened here is in 2000, the then current owner, his name was Mr. Pelosi, he did a gut renovation. He installed this tub. And per the lease, the way that that works is when his lease terminated, that...
You're arguing that it's grandfathered. But here you have a jacuzzi that causes damage. Not only does it cause damage, it's also improperly installed in the nth degree to the extent that the beams underneath are not placed. I'm using the word beams, but it's probably supports. The supports underneath the jacuzzi are not placed over the concrete as they should be, but they're placed beside the concrete. And therefore, the jacuzzi is... its weight exceeds, its load exceeds what the supports can sustain, and you have these leaks. That's the only one, that's the only tub that's leaking in the whole building, so it's treated differently. Why is that not? Why should we not defer to the business judgment rule under these circumstances?
So just a couple of clarifications about the way you explain.
Make them quick because you're out of time.
Yes. Essentially, we're not arguing that it's grandfathered. We're arguing that there's an express grant that flows from the description of the demise premises, which grants fixtures to my client that are then existing when the lease is executed. This was a fixture that was then existing when the lease was executed, and it was installed by a prior tenant, and when that tenant's lease expired, it reverted to the co-op. The co-op could have chose to remove it. The co-op could have done a number of things. The co-op chose to continue to lease it out. It leased it out to 2 prior residents before my client, and then it leased it out to my client. So my client has
Get to the point. So the point is that they are entitled to keep the tub.
They're entitled to keep the tub pursuant to an express grant and not a grandfathering argument. Also, the leak issues that you raised as a factual matter, there's no evidence that the tub itself ever leaked. The leak was traced to the toilet and the shower body. When those were replaced, there was no further leaking, and the floor...
Counsel, you'll have time on rebuttal.
If it please the court, Nick Yanuzzi for the respondent. To jump in there right at the end where counsel just finished off, I would suggest that the bathroom, there's provisions in the bylaws or in the governing documents which say that the bathroom, the water closets must be used for the purpose that it was constructed. And then we have this other provision that we were just discussing where the bathroom must be restored by the leasee. There's so many provisions in the governing documents which make this issue the responsibility of the leasee and not the co-op, particularly because the co-op wasn't aware of this tub until the issue in 2017 when this leak was happening.
Counsel, just to go back to your friend's point that you should not be entitled to attorney's fees, doesn't paragraph 26 have language to the effect of seeking fees as additional rent for litigating a default or, quote, defending or asserting a counterclaim in any action or proceeding brought by the lessee? This is an action for a declaration. It's an action brought by the lessee to get his tub back, correct?
Correct, Your Honor.
And on this record, it was dismissed.
Correct.
Which makes your client a prevailing party.
Yes, Your Honor.
Which would entitle him to attorney's fees, correct?
Absolutely, Your
This
Honor.
has nothing to do with the default, correct?
Nothing, Your Honor.
Okay. Getting back to the other issue, in 2010, the plaintiff had an air conditioning unit installed and actually signed an agreement with the condominium board. Doesn't that agreement make clear to him well in advance that that he had no permission to ever have a Whirlpool tub?
Absolutely, Your Honor.
And he signed that, correct?
Correct, Your Honor.
So
this is a long prevailing policy of the co-op that this sort of tub, the jacuzzi sort of tub, is not permitted in the building. As we've said throughout our record, the co-op is not in the position to go around apartment to apartment to police and check for violations. It deals with them as they come. But the shareholders are on notice. These shareholders are on notice that this Whirlpool-like tub was not permitted. They knew that in 2010, 4 years before their first leak that involved this tub, and then again when they had it again in 2017. The record shows that the shareholder from that first leak in 2014, 2012, 2014, had to continually repair this tub, to continually caulk the tub, because it was continually sinking between those years. And no steps were taken to correct the issue, but this was a tub that was involved with many problems, which he should have known was not allowed. But going back to the idea of this is a longstanding policy, that well, before I get to that, I just want to touch back on the legal fees. I just want to mention that this issue was not preserved in the lower court. The appellants did not address the issue. They said, we'll deal with this issue later. No one knows when that's to be, because if losing the motion, they didn't address it. The same thing with this issue regarding notice. It was not raised in the lower court. It wasn't even raised in the appellant's brief. It was raised on reply. It's they evolved their argument, correcting issues as they go along.
Your friend has argued that this was a grant because it was a consideration for why they took over the space. They saw the tub, and that's why they bought the condo, correct?
That's what they claim.
That's the claim. So, but of course, there's a no waiver provision here.
There's a no waiver provision, and the governing documents have many provisions which discuss that if, for the safety of the building, the board feels that there's an issue or a piece of equipment that needs to be, the board has the power to correct issues that will negatively affect the building. So that falls into this. So even if there was at some time permission, which there is no proof that there is, or no one would claim that there is, the board still has the power later to retract any sort of permission if it feels that there's going to be damage to the building and effect to other people in the building. I would just say that the lower court's decision in dealing with the issue of breach of contract, that the board was well within its power. The appellants have not pointed to any actual provision of any governing document or contract that was breached. It's all sort of a conclusory, mention a lot of provisions without actually saying a breach has ever occurred. And so I would suggest that the lower court decision was correct.
Thank you.
Thank you, Your Honor.
You have 2 minutes on rebuttal.
Thank you. Just on the legal fees point, I would point out that I think The only fair reading of 26 is that the default is in conjunction with any of those other or provisions, and I would
No,
point.
or is not and.
Correct.
Or means this or that.
Correct, but but
So,
it says.
so it doesn't require a default and something else. So your attempt to suggest that we are misreading is falling flat.
Understood. I would just point the court to the Magaluscu case, the Robinson case, the Dupree case. They all construed this same exact language that's common in proprietary leases, where it says a default hereunder and the lesser shall incur expenses
And
in a number
here
of.
it said or, right?
And, but then or. So it's default and a number of conditions. The default is a prerequisite before you get to the ors.
Okay.
I would just
Counsel,
urge the court to look at the First Department cases on that.
Counsel, can you just say briefly how you get around the alteration agreement that was signed in 2010, the one that was referenced by my
Yes,
colleague, which says specifically, I acknowledge that I have granted that the condo will not grant me permission for the installation of a whirlpool.
Correct. That was signed after the proprietary lease had already been executed. He had already taken ownership of the tub that was leased to him by the co-op, and he signed this alteration agreement in connection.
But isn't this notice that a whirlpool will not be allowed going forward, that if it goes out, it's like if you have a big dog and they don't allow dogs, you know? I mean, what's the difference?
At best, I would say it acknowledges no new installations of new tubs. I can't do a repair and put back the existing tub you leased to me. I don't think this in any way eviscerated his pre-existing contractual rights. I also think this fits squarely within the case law like DeNICU and in Goldstein, where the co-op argued, yes, we have this obligation to do things. In one of the cases, Goldstein, they took 50 square feet to do a repair. They were able to do it, but there was still a breach of contract. There's still a grant here that my client had, and that was breached. Thank you, Your Honors.
Lou versus Sagewood. You may proceed.
Good afternoon, if I may please the court. Jacob Chen for the defendant's appellants. The issue before the trial court, before the lower court, was whether or not the plaintiffs, who were members of a company referred to by the parties as Fund 2, investors in Fund 2, should be able to get their investment from Fund 3, a company which they did not invest in or put any money in at all. The trial court held that they can on the doctrine of equitable estoppel, which is not an issue that was raised by plaintiffs before the lower court and therefore was not fully briefed, nor were there any factual affidavits.
So I don't understand something. So your clients told the plaintiffs, the money that you invested in Fund 2 is being transferred over to Fund 3. And there were statements issued and interest and IRS docs and IRS submissions and everything else indicating that the funds were transferred to Fund 3. And that was the end of it. And then lo and behold, didn't your clients say, oh, no, you have to put up the money for Fund 3, you got to put up $200,000 each again, because the monies in Fund 2 were embezzled by my co-manager. I didn't tell you because I didn't want you to feel bad. I didn't want you to get hurt. I thought you might make the money. I don't understand the basis for your argument at all.
Your Honor, you're correct on every point except the very last one, which is the management of Fund 2 did, in fact, Ms. Jingyin Wu did, in fact, communicate that the funds were going to be rolled over and then did communicate that the funds were rolled over, but the reality
All
is...
of which were lies.
All of which were mistakes.
No, they were lies, not mistakes. There was no confusion. Wu lied. She knew that her partner had stolen the money. And instead of being honest with her investors, she lied.
So, Your Honor, to the extent that this comes down to an issue of credibility and the truth.
No, it's not a question. It's not a question of credibility. Your client can't even deny that she lied.
My client did in fact say that the funds were going to be rolled over, thought that the funds were going to be rolled over.
She said they were rolled over. She never told the investors that their money was gone and stolen.
So actually, that part of the record is very incorrect. With respect to Fund 2...
What do you call embezzlement?
With respect to Fund 2, there was notice given to the investors.
No, counsel, what do you call, you said there was no stealing?
No, there was stealing.
Okay.
So the record...
By Ms. Wu's co-manager, right?
That's correct.
But she withheld the information from her investors.
No, that is not true at all.
So at what point did she give them notice that the money had been embezzled?
Before the rollover, Fund 2 notified the investors that there was embezzlement and asked the other members of Fund 2, including the plaintiffs, to oust the embezzlers, and they did. The other members of Fund 2 agreed to oust the embezzlers, and that's how Ms. Wu was able to get control of Fund 2 later on and initiate the process to attempt to recover the money that was embezzled. There was an inquest that was just held in the matter. We are waiting for a judgment to be issued by the court. Fund 2 is still in the process of getting all the money back.
So there was no representation that the funds, their investment from Fund 2 would be rolled over into Fund 3?
Sorry, can you...
I'll make it in the positive. Did Ms. Wu make a representation that the funds were being rolled over from Fund 2 into Fund 3?
Ms. Wu did make that representation.
She did.
She intended to roll over the funds from Fund 2 to
No, but she made that representation, right? Not her intention, she did it. She said, ta-da, money's being rolled over.
That is correct. But the issue before the trial court was whether or not equitable estoppel applies. And the elements of equitable estoppel have not been met. Primarily, one of the major elements is whether or not there was harm to the plaintiffs.
Let me see. I invest $200,000. The co-manager steals it. And now in order for me to have a $200,000 investment in this company, I have to put in another $200,000. I don't know about your math, but that means I'm down $200,000.
Your Honor, the plaintiffs were down $200,000 from...
Isn't that harm, counsel?
How is that not harm?
They were harmed because the co-manager of Fund 2 stole the money. I would note that Fund 2 is still trying to collect that money.
That's nice. That, you know what? That doesn't make the investor warm and fuzzy at night. But I'll give you time on rebuttal.
Thank you, Your Honor.
Good afternoon.
What am I missing here?
Ethan Brusher on behalf of the respondents. You're missing nothing, Your Honor. The client, my clients, were told that their money was rolled over in multiple messages. They were given multiple statements saying that they were members of Fund 3. They were given money. They were given a return of capital, and they were given profit distributions from Fund 3.
Your adversary just said that the investors in Fund 2 were told that this money was stolen. When were they told? Before they were told that they were part of Fund 3?
Absolutely not, Your Honor.
Oh.
Okay, they were told in the summer of 2018 by Ms. Wu that Fund 3 was better, and they were given subscription agreements and operating agreements for Fund 3.
And when does Ms. Wu allege that she told them that the money was taken from Fund 2?
I'm not sure when she told them, but she was told them that they were told in November or December of 2019 that they hadn't put the money into Fund 3.
Now,
I don't think they were ever told there was...
But wait, they were asked by Ms. Wu to sign the subscription agreement to Fund 3 without knowing the truth about Fund 2.
That's absolutely correct.
Okay.
Could you address... I'm sorry.
I just want to ask one more additional question about that. At the time of, when did the embezzlement occur?
We don't know.
But clear, okay.
What Ms. Wu testified at her deposition was that when she told my clients in August of 2018 that Fund 3 was better and they should sign up, she already knew there was a problem with Fund 2, that something had happened, that the fund had been embezzled, but she didn't tell my my clients that at that time.
And at that time, if they knew, they could have taken whatever actions. I mean, that's the problem, right? When you talk about what harm, the harm is that I didn't know at a time when maybe I could have taken action to get my money back or whatever else, right? They only found out so much later. It's hard to say what the harm would be when I didn't know at the time that I was being harmed.
Right, for a year and a half, from August 2018 until December 2019.
And we have no idea whether in that period of time that embezzler took all his money and sent it to a bank somewhere else, or we don't know what happened during that period.
Sitting in Tahiti somewhere.
Right.
Anything could have happened to it.
Right.
I mean, they were also given tax returns or K-1s.
That's what I was going to ask you
2018.
about.
Doctrine of tax estoppel applies. They claim that they gave them amended K-1s for 2018, except that's not true. They were given K-1s for 2019 that weren't amending 2018 K-1s. There's boxes at the top of the K-1s that say amended and final, and it said final 2019 K-1s. They never ever amended the 2018 K-1s. The doctrine.
So, counsel, within that context, would you address the issue of tax estoppel? Because there was a submission of the K-1s that were to IRS.
The doctrine of tax estoppel applies here because they were given 2018 K-1s showing that they were members of Fund 3. They had each 2-point-some-odd% interest in Fund 3. And then in 2019, what they say is they amended the 2018 K-1s, but they didn't. But they were final 2019 K-1s. They never amended the 2018.
So the filings with IRS are dead wrong?
What's on file with IRS is that they were Fund 3 members. The doctrine of tax estoppel applies. Ms. Wu signed the tax returns. She authorized the filing of the tax returns. The doctrine of
What you're saying is these were filed deeming them members of Fund 3 without the need to have to put in money in it. That's the representation, that they were members of Fund 3, correct?
Yes.
So they're held to that. That's what tax estoppel is all about. They let the IRS know that the plaintiffs were members of Fund 3 and they have no right to ask for another $200,000.
Right. Correct.
Okay.
Thank you.
Thank you, Your Honors.
You have 2 minutes on rebuttal.
Your Honors, with respect to the issue of harm, the harm that the plaintiffs suffered was because of the co-manager that embezzled the money. They have a right to go to the management and say—
Well, that was part of their harm. The other part of their harm was the co-manager that was left behind not being honest with them.
So, but the harm, the money that they lost was from the money that was stolen. And the co-manager that was left behind brought the lawsuit to try to collect the money back. When you as an investor lose money in your investment, you have the right to go to the members and to say, I want you to bring a suit. If you don't bring a suit, I'll bring the suit derivatively. In this case—
And boy, can you do that really well when you don't know anything?
But in this case, the management did bring a suit. The fund—
No. But the investors didn't know. So how could they? You know what? This is a circular argument.
So, Your Honor, I will first state that the record doesn't state that the investors didn't know. In the complaint by the plaintiffs, they alleged that they were worried about the money, that they thought the money was going away, and which is why they wanted to talk with Ms. Wu, and that's why Ms. Wu offered the rollover. So that's, first of all, the record, the evidentiary record does not state that the plaintiffs did not know the money was lost. And second, with respect to the harm—
Are you really trying to argue that the plaintiffs here knew that there was embezzlement going on in the first fund?
Yes. Plaintiffs—
Based on what?
I can pull out the record, and I can pull out—
No, based on what?
There was a request by Ms. Wu to oust the co-manager for embezzlement, which the plaintiffs and other members all voted on.
When was that?
So that's after the fact.
This was after the embezzlement, but before the rollover. I need to—
When was that?
This should be around 2000 and I believe 18, but I need to pull out the full record.
I think it was not.
To check.
It was quite a bit later, right?
It was after the embezzlement, but before the rollover. And I just want to end with the fact that if Their rights to collect, their harm was against the embezzler, and they had the right to request the company to bring a lawsuit, but the company did. Fund 2 did bring the lawsuit to recover the funds. They did pursue the legal recourse which the plaintiffs were being entitled to, which is a breach of fiduciary duty action, and that action has been decided in their favor, and they're in the process of collecting a judgment once the inquest is completed.
Thank you.
Thank you, Your Honors.
Black versus LICC Realty. You may proceed.
May it please the court. John Lichtenstein for the appellant, LICC Realty. Initially, respondent agrees that there's no basis in the case for the labor law 242, 241-6, 200 and common law negligence claims, and they should have been dismissed by the lower court that just ignored the argument that we made. As for the labor law 241, this is a good example of sole proximate cause. Entirely different than the Perez versus 1330.
That went so well the last time, but go ahead.
It's different here because this was not a construction site. This was a nursing home. The plaintiff was...
Here the owner needed to have this work done right away because there was an impending inspection of the facility, right?
Well,
that's what the plaintiff says, and I have no evidence in the record to the contrary. Am I correct?
His supervisor told him that sometime later in the week, there was a Department of Health inspection. Maybe it would happen the week after. He was not being rushed. He was not told he was going to be fired if it didn't happen immediately. In fact, the last conversation that he had prior to the accident was the day before when the supervisor gave him the assignment. Then he worked the entire day, came back the next day, and was working for a few hours, never had any conversation with his boss. So nobody was giving him any pressure. He wasn't told that this had to be done immediately. In fact, he started to work at 11 a.m. on the day of the accident. So he didn't even start immediately. That's not even an issue in this case. Okay, the real issue before this court is where the plaintiff was himself in custody of the ladders. These ladders were stored
Can I just go back
in
a
his own
second,
maintenance
right?
shop.
The plaintiff testifies that Azen told him, I need you to finish the dampers, which plaintiff understood to mean right away. I wanted him to do the job and fast and finish it, and that he was rushing him to do it because an inspection was coming. Did Azen put in an affidavit denying that testimony?
Azen was deposed in the case, and
Did he say anything that any of that was false?
well, what he said was that there was.
I'm just
there was
asking you about that. I know, I didn't see him saying, no, I never said anything. I don't know where that came from.
I've never seen a supervisor say, here, do this, do it in your own time.
I'm asking you just about what Azen said or didn't say. Did Azen say that what plaintiff testified he said to him and plaintiff's understanding of that testimony was false? Did Azen say any of that in his deposition?
I don't believe he was asked, no.
Okay. So that is unchallenged.
There was a reason they were doing it, yes.
And let me
He
just
wasn't
ask
being
you, were
rushed.
there any taller ladder, did anyone testify that there were taller ladders on the premises on the day that plaintiff could have used?
Azen did testify to that.
He said there was.
Yeah, that
Based on
information was cited to the lower court.
That they were available in the closet? He didn't say that.
They were in the building. It's undisputed that they were in the building.
Again, it has to be available for the worker to use, okay? A worker doesn't have to go traipsing through the whole building to find the equipment that he needs to do the job his owner of the building asked him to do. That's not what the labor law says.
Again, this is a situation where Mr. Locke had custody and possession of the ladders.
It doesn't matter. Our case law says that doesn't matter.
What your case law says is if the worker knows that what he's working on is inappropriate, and he knows that there's an available ladder in the building, that he has to either go get it or he has to ask for it.
What case says that?
That is the Robinson case, Court of Appeals. It is the Moreau case, which is this court's case, which was then affirmed by the Court of Appeals. It's the Montgomery case, and it's also the case that Judge Higgett cited, Gallagher. That is the law in this state.
But he said he went and he couldn't find them. So is there anything to challenge that testimony? He looked around, he couldn't find the ladder.
That's what the court has to decide, whether his cursory inspection, he looked in 2, maybe 3 places, he didn't then, he didn't ask.
We're not going to get that granular.
Oh, my
That's
God.
so granular. He said, I looked around, I couldn't find it.
That's the rule we should adopt? You have to look for at least 15 minutes to find the equipment you need to be safe when you're asked to do work for your employer.
There is no rule like that. There's no, and I made that point, there's no diligence argument or element here. If he knew that what he was working on was not appropriate, and he knew that there was other devices available, he had an obligation, okay? That's what the Court of Appeals has said in Robinson.
But in Robinson, didn't the worker know where the ladders were, but didn't go to that location to seek them out? Whereas here, there was a bit of a hunt for a ladder, and it was fruitless?
Well, in Robinson, I would say Robinson is a worse situation because he actually asked his foreman and told his foreman that he needed the ladder. But he didn't wait for the foreman to get him the ladder. And the issue with Robinson, well, you know, he knew, I don't know if it was developed that well, if he knew precisely where it was. But here, there was somebody holding a gun to his head. It was a 6-story building. It was a nursing home.
Except he testified that there was. And there's no testimony that disputes it. He said, they wanted me to do this right away. I felt pressured. I felt it. And Azen didn't deny that.
You'll have time on rebuttal.
May it please the court, John Shaw for plaintiff respondent. Basically, counsel.
Why isn't he correct? If he knew that he couldn't do the job or that he really needed a taller ladder, why didn't he go searching for the ladder instead of risk falling?
Well, maybe if we're in a different state and we didn't have labor law section 240-1, which counsel should respectfully take a look at, maybe would be a different scenario. But here, as Justice Scarpulla noted, which would not even be the ultimate prerequisite, the record is uncontroverted that the supervisor, Azen, rushed him for the day and said, get the job done. Secondly, my client actually looked for the ladder, and the only place it would be available would be in that workshop, and he went with his coworker. He was even diligent.
Did he look the day before, or did he look on the day of the accident?
The day of the accident.
Of the accident, not just the night before?
He looked the day of the accident when he was told and rushed to do the work, and it was not there. It was being used. There was only, at most, another ladder that may have been available, and the only ladder for his use was this 3-foot ladder where he was directed to rush and do the job. Not only that, Your Honors, which would not be a basis for denial of summary judgment, as this court knows, he was never even directed by anyone, and this is again uncontroverted, page 265 of the record, that the stepladder was an inappropriate safety device. No one directed him not to use it, and as Your Honors know, a safety instruction not to use a safety device that's inappropriate does not constitute a safety device. And as Justice Higgett noted, counsel is clearly misreading the record and the opinion in Robinson. Robinson is...
But I want to just ask you, just as a matter, like, this is a little weird because isn't he a one-man shop? Is there anyone who would have instructed him about that?
It would not have mattered if anyone instructed him regardless. That's not, I mean, under the Court of Appeals, counsel wants this court to reverse what the Court of Appeals says.
No, I'm not, I'm just,
Oh, yes.
just as a general matter, if you're the boss, right? If you're
Right.
the one that's supposed to be giving you safety instructions, how does that play into this, right? Isn't he his own boss? He's the one?
He's not his own boss, and even if he was an independent contractor, and when there's many cases in this
Right.
court, in the Mata case.
Yeah, but there's usually somebody else who's, you know what I mean?
Right.
That's what I thought was so interesting about this case.
No, sure, but even if he was an independent contractor and his own boss, and the owner or the general contractor did not provide the safety device, they have a non-delegable duty. And very briefly,
And here, didn't the owner say that had he seen the plaintiff using this small ladder to do this job, he would have told him not to because it was not the appropriate ladder to use? Isn't that what he said?
correct.
Oh.
Correct.
But he didn't tell him, by the way, that little ladder, don't use that one to do this job that I need you to do right away.
No one told him not to use it, and it wasn't available. And in the Robinson
Well,
case,
for a sole proximate cause analysis under Gallagher and Cahill, what does it mean for the device to be quote unquote available?
it has to be readily available. In Cahill, the worker supplied his own advice, and he knew that he misused it. Here, my client, the only device available was this 3-foot ladder, and it failed. And he actually diligently searched for it, and that would not be his burden.
Issue, I have a notation here that the record at 225 says that the plaintiff did not make any further attempts on the day, the plaintiff made a search for the ladder the day before the accident, and he testified that he did not make any further attempts to locate the other ladder prior to starting the work on the day of the accident. So could you just give me a record site, if possible, as to where he said that he looked for the ladder on the day of the accident?
Again, not that that would be a prerequisite, but page, give me 1 second. Pages here. Pages 206. Yeah, how pages 206, 201 and 203 and 206 and 27. When he went with Luna, they were looking for the ladder.
That's the day of the accident?
No, that was when he was installing the ladder on I believe, on the day of the accident.
Oh.
Yeah, pages 206.
Thank you.
How about a question? Question, how about on the day you were installing the damper on the 6th floor, did you have any discussions with anyone in the building? Yes, I asked where the ladder was. They couldn't tell me where the ladder was. And then he went on an expedition with Mr. Luna looking for the ladder, but it wasn't available. That's when he searched for it, Your Honor. And then pages 201 and 203. But hypothetically, even if he did not search for that ladder, which he did, that's not his obligation. There was no ladder available in the one that he used. And in Robinson—
Can I just ask you a quick question?
Sure.
You're not disputing the dismissal of 241-6, and you didn't argue it on appeal, right? You didn't argue that anything about those. You sort of said nothing about them.
Clearly, he cannot be the sole proximate cause of this
No, I'm
accident.
talking about 241-6.
Oh, I'm sorry. I misheard you, Your Honor.
I'm talking about 241-6 and 200. You're not disputing those. Okay.
Correct, Your Honor. That's not in dispute. And in 10 seconds in Robinson, as Justice Higgett pointed out, a totally different set of facts. The plaintiff was aware and admitted that they were readily available, the 8-foot ladder. He knew where it was, and unlike this case, he even admitted, and the foreman testified, that it was not even required that they do the piping work at that time. He could have done other work, but he chose not to. Here, it's a completely different set of facts. Thank you.
Judge Gonzalez,
Please.
You're right. It was the day before, he was on the 6th floor. The day before, there was no search at all, notwithstanding that the day before, he was working and installed.
Sorry, I'm not understanding you. The day before, there was no search, or there was a search?
That's when the search occurred.
That's when the search
Day
took
before,
place.
when he was
Your
installing.
adversary's referencing 4 pages, 201, 203, 206, 207. Are you saying that those record pages don't indicate that there was a search on the day of the accident?
That's what I'm saying, Your Honor. I know this case. I was there at the deposition. I don't have the record in front of me, so the court obviously can check those page numbers, and they should. The point, he spent the entire day on the 6th floor. I asked him at his deposition, well, did you look on the 6th floor for a ladder? Did you look on the 5th floor for a ladder? He said no. He said no. He only performed the search, this cursory search, where he checked 2 locations, his storage room and the laundry room, and then he went out to the garbage for some reason, didn't see it, and then started work. The next day, I asked him, did you do a search when you got to work the next day, the day of the accident? He said no.
May I ask another question? Yes. So with respect to availability and respect to the questions that my colleagues were asking previously, is it your position that the plaintiff was obligated to make a search, or is it correct to say that the ladder needed to be readily available in the immediate vicinity?
I don't think those two things are mutually exclusive. In the Robinson case, the court said,
I
the
need you
court
to
said,
answer the question. Does the ladder have to be in the immediate vicinity, or does a plaintiff have a duty and an obligation under the labor law to go search for his own safety equipment?
that's an easy one. It definitely does not have to be in the immediate vicinity. The Court of Appeals has said that.
And a plaintiff has an obligation and a duty to go search for their own safety equipment?
In Robinson, it says.
Is that a yes or a no?
Yes, yes. The worker is obligated to utilize a normal and logical response to obtain the appropriate safety device. Okay? He's obligated to do it. In Moreau, this court's case.
All right, I'm going to give you 30 more seconds because you had 1 minute and you are already past that 1 minute.
Thank you, Your Honor. This is critical. This is the standard. Plaintiff who knowingly chooses to use inadequate equipment, notwithstanding being aware that he or she could request or obtain proper equipment, has no claim under the labor law. That's this court's decision. It was affirmed by the Court of Appeals in Moreau. And that's Robinson as well. That's what the standard is. He could have asked for it. He could have went in and obtained it.
So you're saying that a worker has to ask for the safety equipment they need to do the job they're assigned, and an owner doesn't have to provide it in the first instance?
He is where the worker knows he's using an inappropriate device, where the worker knows. Okay, most situations,
seems to be
they don't
turning
know.
labor law on its head.
This is the one situation where the worker, it seems to me that in my experience, is obligated, where they know they're working with something that's inappropriate. The Court of Appeals has said they have to act logically. They have to ask for the appropriate device or go get it. And in this situation, 6 years after the accident, 6 years, he remembered the colors of the taller ladders in his own possession. Blue, orange, metallic. It's like he went to bed with them at night.
All right, on that note, Fall versus Greyhound. You went to bed with them. Really? You have 4 minutes.
Good afternoon. My name is Diane Toner. I'm here for appellants. So this case involves a motor vehicle accident, and plaintiff is alleging serious injuries to both of her shoulders as well as a traumatic brain injury. We moved for summary judgment, and we submitted evidence that she did not have a traumatic brain injury, and also
Don't we have competing affidavits from her experts and your experts, and why isn't that a quintessential issue of fact?
Good question. So we met our burden in submitting the affidavit of our experts. For example, we have the affidavit of the two radiologists saying that the CT scan and the MRI results showed that she did not have any objective evidence of a traumatic brain injury. We also have the neuropsychologist stating that the results that she had on the tests as they progressed from closer to the injury to further from the injury, they got worse, and given the other testing that he did of her, he concluded that she was not being forthright in her evaluations, and he concluded that she did not have a traumatic brain injury. There's some dispute as to whether the tests that were used by the plaintiff's treating doctor are accepted by the medical community in order to diagnose a traumatic brain injury. So specifically the MRV, the NeuroQuant, and the DTI, we submit, and our expert stated that those are not widely accepted for diagnosing traumatic brain injury.
I thought it was only one of those tests that was at issue, not all three.
So in our main
now it's all three?
In the main expert affidavit, we addressed the DTI, and then in reply, we submitted another addenda.
Well, in reply, you can't do that, can you?
Well, it was
that was certainly something you could have put forth in your case in chief.
Yes, you're correct. So regardless of whether these tests are accepted, even if they are accepted, our expert addressed the specific findings on these tests and concluded that they did not support a finding of traumatic brain injury. Also, we would note that—
Counsel, isn't this a classic example of competing medical opinions?
That's what I said.
I mean, Dr. Golzad, how do you say it, found headache, dizziness, memory and cognitive deficiencies, daytime fatigue. She received cognitive remediation therapy, physical therapy, and balance therapy. Aren't those classic indicators of TBI?
Well, I think what's missing here is a causal link between the accident.
But she had no prior TBI symptoms or
Her testimony is that she had no prior symptoms. However, she also did not testify as to how the collision impacted her body, whether she hit her head or her shoulders. And so we submit that it's missing a causal link. There's no physiological description of how the accident caused these supposed injuries.
Typically, accidents are something that happen like that. And the requirement to ask someone, the moment it hit, my body propelled to the right, and then, I mean, it's unrealistic. That's just not how human beings remember and kind of do memory recall. That's just not how our brains function.
Yes, I understand, but here, this is a light impact rear-end collision with no airbag deployment.
Counsel, she didn't remember most of the details of the accident. She remembered that the Uber was stopped at a red light, and then when she opened her eyes, she was on the next block. A police officer was asking her if she was okay when the officer opened the door. I mean,
that's her testimony, and yet she could not remember the impact of the collision. And
exactly. Exactly.
That's the whole point.
That's the point. But you'll have time on rebuttal.
Thank you.
Counsel?
I see that the court is familiar with
Could you make your appearance, please?
I'm sorry?
Make your appearance.
Oh, yes. I'm Stephen Chackman for the plaintiff. I'm from the D and Left law firm. And I am starting off sort of sideways on this because of the question that you asked Justice Benzonet, and that is about the experience of being in a car crash. I was in one, and I was an experienced personal injury lawyer at the time. And if you asked me a week later what had happened, you would have gotten oatmeal out of me, but no words. In this case, you have a woman who is brain injured. You have excerpts from her testimony quoted by the defendants, and they say this doesn't make sense. But it makes sense because that's the way some brain injured people speak. Now, she went through the testing she went through. There's no expert that they have that I found who says the MRV is anything other than diagnostic of a problem with blood flow to the brain. I set off, at length in the brief why what they say about the DTI is just not real.
Well, counsel.
Yes, sir.
What is clear here is that you presented expert testimony, if you will, from her treating doctors, wasn't correct? Yes. So, in fact, she was treated shortly after the accident, showing cognitive deficit, headaches, things that are easily attributable to TBI, correct?
Yes, Your Honor.
And through the 2-year period from 2018 to 2020, by the very expert you introduced to counter their motion for summary judgment and the medical records relied on, that was what you put in opposition.
Right.
Their personal knowledge, their findings, which create an issue of fact here.
Yes, it is an issue of fact. This is the case for a jury. I can't see any way that it isn't. You can't say as a matter of law that this radiologist is right about what a DTI can show, and this radiologist is wrong about it. You can have a Fry hearing for that, but nobody gets a Fry hearing on a DTI anymore. The courts accept them. But yeah, we have to go and try it. Well, I'll rest on my brief. Thanks.
Thank you. Also, you have a minute.
Thank you. Well, I dispute the idea that DTIs are widely accepted by courts or medical community. I think that's still an open question. This court had one case, La Masa, in which it addressed obliquely the DTI tests, but it was in the context of a trial in which other evidence was put forth as well.
Well, isn't there other evidence here, right? Doesn't her treating doctor, who's seeing her and seeing her cognitive defects, come to the conclusion that she's suffering from DTI, right? Based on his observation, his work with her, not just that one test. We can even take out that test, but clearly he does.
True, but
and you still haven't even talked about the shoulder injury, right?
Correct, we have not talked about the shoulder. With respect to the...
Both doctors saw the bilateral tear in the shoulder, right?
Defendants attributed her injuries, well, the orthopedist said that she had full range of motion in her shoulders when he tested her in 2020, and the radiologist said that...
That was after the surgery, right?
She didn't have surgery.
She had no surgery?
No surgery.
Okay. I
No,
thought she had
so she had
surgery.
full range of motion in her shoulder.
But I mean, they both agreed that there was a tear in the MRI taken after the accident, right?
The MRI reports that were done by plaintiff's doctors found that there were tears, but defendant's doctors found that there was osteoarthritis in her shoulders.
She refused the surgery, now I remember.
She declined the surgery for
Okay.
personal reasons.
All right.
Unless the court has further questions, I will rest on my briefs.
Thank you. And last but not least, People versus Garcia.
Good afternoon.
Good afternoon.
May it please the court, Lena Janota on behalf of appellant Amar Garcia. We are asking the court today to run Mr. Garcia's sentences concurrently where there are mitigating circumstances relevant to how the crime was committed, specifically the lack of physical injury. Now, the Court of Appeals and this court have established that a lack of physical injury is a mitigating circumstance under this provision. And that's Penal Law 7.
I think your biggest problem here is that your client was out on bail and then commits this crime. That's a problem. That's a real big problem.
That is
how does any mitigation that you can offer this court balance out that?
My client does have a prior felony. That felony conviction, he was out on bail from when he committed the first offense. That's true. And my client committed 2 very serious offenses, and we are by no means trying to undercut the gravity of those offenses. However, his prior contact, including the conviction that you mentioned that he was out on bail for, were already taken into consideration when he received the sentence for the second offense. And that was a 7-year sentence. So Mr. Garcia received a very serious sentence for an offense which resulted in no injury. And I also want to highlight that that 7-year sentence was significantly higher than any of his other co-defendants by virtue of his prior contacts with the system. So those other contacts have already been taken into consideration, right? His other co-defendants received a 3-year sentence and a 1.5 to 3 sentence. Here, he committed a serious offense. He received a serious sentence. Nobody was injured. He was extremely young.
When you say nobody was injured, he entered the victim's apartment, pointed firearms at her head, and told the victim to give him and his co-defendant the money. He took her phone, $500, an expensive
which he was wearing when he
handbag.
was arrested.
Mike,
I mean, this is, look, you know, this isn't all right, I got caught with a gun and I live in a bad neighborhood, so I'm gonna keep on carrying that gun because I have to stay alive and I get caught again with a gun. This ain't that case, right? This is, I get caught with a gun, I'm on bail for that, and then I go and I do what sounds like a push and robbery, put a gun to somebody's head, steal stuff from their house in a group, okay? I can't think about anything more horrifying than that, right?
We're not disputing the gravity
So
of this offense.
what was he supposed to get after you're out on bail for a gun, and now you grab another gun, and you rob somebody in their house and put the gun to their head?
First of all, I will not concede that my client was holding a gun. He was a part of a group.
Somebody did.
And that's true.
And he benefited from it because he was wearing the jacket that was stolen from that house.
That's absolutely true.
You and I both know it doesn't matter whether he had the gun in his hand or not.
He was a part of this group, and this was a very serious offense. But again, an offense that he received an extremely long sentence
So
for.
again, what is the right number for this fact pattern?
7 years instead of 8.5 to 10.
So let me just ask you, didn't he waive his appeal?
He did sign a waiver of appeal.
And wasn't there a significant colloquy with the court about the waiver of appeal?
An insufficient colloquy. I'd be happy to
Counsel, where is
discuss.
it insufficient? I read it and I thought in many ways it was exemplary.
I seriously disagree, and I'd
Well,
be happy to
how-
explain
how?
that. First and foremost, the court failed to distinguish between the two essential components of the right to appeal, which of course can never be waived, and the right to waive certain appellate issues, which can. Again, the colloquy not only failed to distinguish between those two concepts, but the court repeatedly conflated them. And you can see that in my brief where there's a stark contrast between the colloquy the court provided and the New York model colloquy.
So here, the judge said, by giving up your right to appeal, you are giving up a certain set of legal rights, sir, that are completely separate, completely different from all the rights that you gave up automatically by pleading guilty. So where is there no separation of the two?
At first, the court describes the right to appeal, which of course can never be waived, and the court did not make that fact clear. And then the court segues into...
Right to appeal can never be waived?
The right to appeal can never be waived. The right to appeal is a constitutional right enshrined in the New York State Constitution. The Court of Appeals and People v. Thomas made that clear in 2019. You can't waive your right to appeal. You can waive your right to appeal certain issues. And the court did not make that distinction. It conflated the two concepts, and it failed to inform him that he had the right to counsel on appeal. And all of this happened after he pled guilty, which this court, at a minimum, has acknowledged is not best practice.
Yes, but we haven't reversed solely on that basis. But you'll have time on rebuttal.
Thank you.
On rebuttal.
Good afternoon, and may it please the court. Paul Anderson for the people. Your Honor's covered the nature of the offense. Your Honor's covered the appeal waiver. But I think we have a threshold issue here in that concurrent sentences would be illegal here without a certain fact finding under 7025, and that fact finding never occurred. And so this court has found in Hamlet, DeLorbe, Fourth Department, and Dunbar that if you don't make that application, the court is constrained to run these sentences consecutively. So it's not just simple broad interest of power jurisdiction, or interest of justice, power, and jurisdiction to review the sentence. It's a fact finding by the sentencing court, or with the opportunity of both parties to present relevant information of were there mitigating factors that bear on the circumstances.
So are you arguing, based on what you're saying?
Yes.
That unless we find that there was something invalid about the waiver, this court can't even consider what plaintiff is requesting?
I think even if there is no waiver whatsoever, this court still couldn't consider it. But we have the waiver.
Cannot,
Cannot, because there is no 70-25 application.
Okay,
Because
so
this-
if we, all right, forgive me, I just, if we find that the waiver was improper or something was wrong with the waiver, can we send it back for the court to, can we send it back on this issue?
I'd still say no, Your Honor, because it'd be forfeited, because it was,
Wait, but can I just follow up with one question? Because it's unpreserved?
it's unpreserved
Oh,
and forfeited,
okay.
and forfeited, because
Okay.
there's no fact finding. They never asked for the fact finding. You can't, there's really nothing here for the court to review.
Right, but if we say, you know, this waiver was not good, the plaintiff, the defendant here did not knowingly and intelligently waive, right? So therefore, why can't we send it back for the court to consider, to go back toward the plea and determine and allow defense to make whatever applications they see appropriate and have the court consider it so that we can consider it on the merits? Why can't we do that?
So I have two answers.
I'm not suggesting
I know,
we want to, I'm just saying, why can't we?
I appreciate the exercise. So I have two reasons here. One, it's not a must consider, like youthful offender, in which a court has to consider these factors, so there's no reason to send it back. Two, if that's a remedy to be considered, it's best done under ineffective assistance of sentencing counsel. If we have these things here, he should get resentenced and have the opportunity for counsel to make what application wasn't made below. But there's good reason why he didn't make the application, because as Your Honors pointed out, there really isn't any mitigation. There wasn't any anything to show his participation was limited. And here, given the absence of that fact, and even just the fact finding in general, the sentences have to be consecutive. It's illegal for her without making that finding first. And if we look at all the cases in which in which courts, including this court, has evaluated this similar mandatory consecutive, except for mitigation, all the times that the court has changed and run the sentence concurrent is because there's been an application made. There's been a full record. There's been even on reply, People v. Greyhound, which is a First Department case from Manhattan County, saying that under the 2C, which is the bail jumping provision, that there was a full application made at the court below that this court was able to look at. But in the absence of that application, because this isn't, the court must consider sua sponte that whether consecutive or whether concurrent is appropriate. The claim doesn't lie here. It's non-cognizable here. So in addition to, as Your Honors pointed out, the nature of the offense itself, the valid appeal waiver, I think we have an issue of we can't even get past that. The fact that this is not a cognizable claim raised for the first time on appeal, and that's concordant with all the other divisions in the state. So for these reasons, I ask you to affirm. Thank you.
Thank you. All right, counsel. Why don't you address that issue first?
Sure. First, I need to make clear from the outset that we are not requesting that this case be sent back. We are simply asking this court to make a sentencing determination. Now, as it relates to that, this court routinely—
Can we?
Yeah.
Based on your adversary's arguments, are we restricted from doing so in light of the fact that there was no application made at the time of sentencing and no mitigation record placed by the sentencing court?
I would love to respond in two ways.
Great, go ahead.
First, this claim does not need to be preserved. This court routinely adjusts sentences within the permissible statutory range based on the record before it. This is absolutely no different.
But here we're dealing with a special statute that has a special requirement. There's almost a presumption of consecutive sentences under 70.25. And if a court wants to deviate from that, it has to make certain findings specified by the statute. Normally, defendant is sentenced to X. There was a permissible range of sentencing, and we feel that the better sentence is Y. We don't face, as Justice Manzanet Daniels pointed out, that barrier of having to make a special finding required by a statute.
Respectfully, there's nothing special about this statute. It's like any other article, provision in Article 70. It informs this court about what the legal sentencing options are. You are absolutely correct that under these circumstances, it's mandatory for a sentence to run consecutively unless there's a finding of a certain type of mitigation. One of those pieces of mitigation is apparent from the record.
Counsel, doesn't that
before you.
mean that the people don't have an opportunity to dispute your mitigation testimony because you didn't do it below? You don't get to just put it in on appeal and not and say consider it court without them getting to go. I mean, isn't that the whole purpose of putting it before the trial court? So you can put in your evidence, they can put in theirs, and the court can make a reasoned decision on it?
They absolutely have an opportunity to present evidence in opposition to this. They've done that. They spent several pages of their brief highlighting information in opposition. They just stood up and highlighted all of those facts before you today. Like every excessive sentence claim before this court, we are all constrained to the facts before it. Would I also love to go back and present additional information to help show this court and any court what kind of a person my client is beyond the four corners of this record? Yes. But like every other sentencing determination this court has made, we have a record here before us. This is not a situation where Mr. Garcia pled guilty at the second appearance. There is a record for this court to make an independent determination and to find, again, that there is a lack of physical injury. That itself is enough mitigating
But that
circumstance.
alone doesn't win the day.
It did in People v. Reyes and People
That's
v. Santiago.
nice, but that alone, that doesn't mean that automatic you win, right?
That in addition to the fact that my client was 21 and again set to serve 7 years in prison. The difference that we're talking about is 7 years versus 8.5 to 10. That is all we're asking, is that this court find that given the lack of physical injury, given the fact that he was 21, given the fact that he's about to serve 7 years in prison based on a crime that he committed before he was 18, he's not going to be ready for release until he's almost 30 under the concurrent sentences. That is all we're asking. And this court has the authority to do that.
Thank you.
Thank you.